Hello again. This is Ben Hitchcock Cross talking to you today. I have testimony from the Milwaukee Public Schools School Board President, Missy Zombor, in the case of Teresa Falaron versus the Milwaukee Board of School Directors. And I'm going to read some of it to you. This is the second day. She got about 15 minutes of examination in on the first day, and we're going to start from there. We've got plenty other stuff, but I just thought I'm working on this now, and I thought it'd be a good time to read it there. So we'll see how it goes. All right. Bam. You are still under oath. Phew. Are you a member for the Milwaukee Board of School Directors? Answer yes. When did that start? April of 2023. Question. Okay. And you're still one now? Yes. Question. Do you have any office on that board? I'm the president as of a couple of months ago. Question, okay. And before that, it was? Answer, citywide school board director. Question, I understand. The president of the Milwaukee Board of School Directors before you was Marva Herndon. True? Answer, yes, correct. Okay, before that, it was Bob Peterson, right? Question mark. I believe so. Yes, correct. The day before, the witness testified that she had contacted Bob Peterson um, just to see if he was also going to be a witness. So then, question. Okay, so I'm going to show this to, and I'm sorry, I want to be clear. There's an issue right now of the judge making her go out of order and saying that we sent her a subpoena for 9 o'clock, so therefore she needs to be ready. In fact, we sent her a cover letter that says, please call our office. She testified that instead of calling our office, she contacted the attorney and then sat in the hallway. Okay. Then complained that I was making her sit in the hallway. So right now we're going to go over the cover letter. We'll see what they allow that to go. Because remember, the judge allowed her to go, even knowing what the cover letter is, because the judge has it. I'm going to object. This is the attorney for MPS. I'm going to object to the relevance of this document and the fact that it was not provided to us as part of the anticipated exhibits in this matter. She's here. She corresponded with the subpoena or responded to the subpoena. She's here to provide evidence about the complaints of the complainant. I don't know what the point of this is. Here's the hearing examiner. I mean, this was talked about on the record yesterday. I don't need to have any additional testimony on it. The document, which he refused to allow us to discuss, speaks for itself. But I will allow the document in. Do we want to mark this as where did we leave off? Court reporter says, we're ready for C10. The hearing examiner says, we're ready for C10. All right, we can mark this as C10. Now, a question to the witness. Did you receive this document? And the attorney for MPS says, I'm going to renew my objection to the relevance of this line of questioning. ALJ DeFort, we are covering new information. Or did you already cover this yesterday? Mr. Hitchcock Cross, I didn't have this document yesterday, so I could not have asked her if she received this document yesterday. The hearing examiner says, this is your document. Mr. Hitchcock Cross says, I don't know what that means. I'm really wary of answering questions for you. What do you need to know? Question mark. Hearing examiner. Okay, this document is a cross law firm document that was drafted up. It looks like dated June 17th. Are you saying this is a document that you did not possess? That you do not possess? Mr. Hitchcock Cross, I didn't say that, no. Okay, so you have this document. Mr. Hitchcock Cross, I don't know that I said that either. ALJ DeFort, did you ask about this document yesterday? Oh, that's something I could answer. Mr. Hitchcock Cross, yes, I asked. Examiner DeFort, okay. Mr. Hitchcock Cross, about this document yesterday. We didn't identify this document yesterday. ALJ DeFort, okay. Mr. Hitchcock Cross, okay. Examiner DeFort. Well, for the record, it is a cover letter with a subpoena. Mr. Hitchcock Cross. So I want to be clear. I don't know how you conduct hearings, but generally the hearing, ALJ defort. Do not interrupt me. Mr. Hitchcock Cross, the witness is the only one testifying. ALJ defort, do not interrupt me and not the ALJ. ALJ defort, this is do not interrupt me. This is a document that is a cover letter from the Cross law firm, and there's a subpoena. So that the record is clear, this is Exhibit C10. And there were questions about this yesterday afternoon towards the end of the day. This document appears to speak for itself, so I don't see the need in getting down this rabbit hole any further. There's already been a record made of this yesterday. Mr. Hitchcock Cross. Well, so there's no record of this witness receiving this document. So for evidentiary and for the record, and for the people who aren't you, we may need to have that record established here. So that's all I'm trying to ask for. But the fact that you're considering limiting me asking this witness if she receives this document, I think that shows your bias for all to see. ALJ defort, was this not testified to yesterday? Ms. Colbert, we took testimony. ALJ defort, I'm asking respondent. Ms. Colbert, we took testimony yesterday regarding the subpoena that she received, the fact that she had been here waiting to testify, and so that's the basis for our objection. It's no longer relevant. She's here to testify in response to their subpoena. I don't see what this has to do with anything at this point. ALJ defort, yeah, at this point it's cumulative and irrelevant. Mr. Hitchcock Cross, it's impeachment is what it is. So now, first of all, we don't even know if you're refusing to allow or to even ask the question. The document is in the record. If she's sorry, what? Your document is in the record. Okay, the fact that it's in the record, the fact that she has received this document is not in the record. ALJ defort, you can argue from the face of the document, as you did yesterday, what it actually says. And yesterday, you established that the witness did receive the letter, subpoena and the cover letter. That was testified to. So you're wasting time. This is cumulative. Mr. Hitchcock Cross, well, we don't know this witness received this document is what the problem is, this document. And the easy solution is to have her respond to the question that's posed. ALJ defort decides that he's going to ask the question, and he says, fine, is this the subpoena that you received from the Cross law firm? The witness says, yes. The hearing examiner defort says, all right, now we're going to move on. By Mr. Hitchcock Cross, and the cover letter as well. You received that from Cross law firm. Same objections. The document is C10. That's the entire document. Sure. You just asked the question, did she receive the subpoena? ALJ defort. It's in the record. Mr. Hitchcock Cross. My question to you, ma'am, is did you receive the cover letter as well? ALJ defort. It's in the record. Move on. So you're over. I don't know that there's an objection, but you're refusing to allow her to answer that question. Is that right? Move on. It's cumulative. That's correct. Move on. It's cumulative. Did he allow her to answer that question at all? Why would the judge prevent her from answering that question and go to such great lengths to do that? I don't know. You tell me. By Mr. Hitchcock Cross. Did you follow the instructions in the cover letter on the subpoena given? This was also discussed yesterday. This is cumulative. Mr. Hitchcock Cross. So now I'm impeaching her is what I'm doing. She said she made statements yesterday that was not clear about what that was. I'm impeaching her with the contradiction. That's how this works. Ms. Colberg, I'm just going to renew my objection to the relevance of this entire line of questioning. Second of all, that's not how impeachment works. If there's some sort of inconsistent statement that's relevant to the proceedings, that's how impeachment works. He's testified that he wants to delve into whether the circumstances are surrounding the delivery of the subpoena. The fact that she was sitting in the hallway yesterday, none of that matters. She came here to testify about the complainant's information. That's correct. Let's move on to the substance of your case. Mr. Hitchcock Cross, it's not the correct. I am planning on asking those questions, so let's be clear about that. You're again taking the evidence, the word of this attorney, on face value. The evidence is what's before you. I haven't even asked that question yet. ALJ defort. I was here yesterday. Mr. Hitchcock Cross. The only question is pending is did you receive the cover letter? That's it. I was here yesterday. Okay. And you asked her about the document and the cover letter. It's painfully clear on the record what we're talking about, and there was a full record of that from yesterday. You have supplemented that with this document today. There is no need to go into this cumulative evidence. No, it's called impeachment. I'm trying to contradict her previous statement with the statement that she made now. It's not relevant. How is that cumulative? It's not relevant. And it's not probative of the issue of the case. Well, whether she's telling the truth is not probative to the issues in the case, because that's where finally and ultimately need to be clear on, sir. So let's have that out. Is that what you're saying? Whether this witness is telling the truth is not probative? She testified yesterday about this document. Right. And now I'm asking her different questions about this document. Okay. That's because I don't think what she said was the truth. I move. So, and you can argue based on her testimony whether or not you believe that she's telling the truth. Sure. It's already in the record. What I need, and to be clear, is a ruling here that says that you are not going to allow me to ask questions on the basis of relevance, because questions of whether or not this witness is credible, it's cumulative on the basis of relevance. Cumulative. You already covered that yesterday. I understand. So now we're clear, I think, for the record. Okay, okay, I understand. So, do you know what deliberate indifference was consonant? Yes, how do you know that? Before I was even on the board, I was told that you have a YouTube channel called Deliberate Indifference. Okay, who told you that? I don't recall. Okay, and then what action did you take and have you reviewed Deliberate Indifference Wisconsin? At this point, we've established that this is the complainant's attorney's YouTube channel. I'm going to object to the relevance of this line of questioning. New objections that school board member took office in 2023 and was not present during the time of the complainant's allegations at the heart of this case. Okay, so based on the filings, there's already been litigation in this case that identifies what deliberate indifference Wisconsin is. It's a YouTube sort of program, and I need an offer of proof as to what is the relevance of this witness viewing this YouTube program in relation to Ms. Folleron's case. And then we ask the witness to leave the room. And then we go through. Let's just keep in mind that under Wisconsin Fair Employment Act rules, only cumulative, meaning repetitive evidence is to be excluded, and irrelevant evidence is not to be excluded. So that's what a lot of that fight was, because he kept saying that things were irrelevant, which he well knows that that's what the rule is. And you're going to see him go back and forth throughout this trial in terms of, is relevance in, or is it cumulative, or what is actually the rule there. And because he said he wouldn't allow it to happen, he wouldn't allow her to be asked the question whether or not she received the cover letter. That cover letter there that we put in front of her, because it was cumulative. Okay. Here we go. I guess I make a motion. I guess let's read the motion. Okay. There is an offer of proof. Got it. Okay, just renewing my objection on this absurd hearing where we can't even get, I would say, 2 questions out without your interference. So far, we've tried to ask the witness several questions just on did she actually receive a document? And you've decided that she doesn't have to testify as to her knowledge of ALJ defort. We've already heard your arguments about that. So what is the offer of proof that you have? Mr. Hitchcock Cross, I'm using my time right now. This is not. This is our shared time. Excuse me here. I'm using my time right now to make a motion here and to protect the record about your bias. So that's something that I have to do as part of my job, and I will be doing it every time. ALJ defort. The question is, Mr. Hitchcock Cross, excuse me, every time you display bias, you're going to get a motion from me to recuse yourself. And again, you need to, based on your display of the record here of your bias against the complainant, by refusing to even allow this witness to answer questions on whether she received a document that's already in evidence that you. The question is an offer of proof. Do you have an offer of proof? Mr. Hitchcock Cross, excuse me, I am still making my motion. Kindly do not interrupt me when I'm making my motion. So based on that, and now again, you're interrupting me when I'm making a motion is also another display of your bias in this case. And it's improper. Bowen, I would say Fowtech and other cases by the Labor and Industry Review Commission make it clear that these kinds of displays by a hearing examiner are not only improper, they are de facto violations of due process. ALJ defort. Now you just made a false statement. Fowtech says offers of proof. You are required to make an offer of proof, so make it. Okay. And again, now make the offer of proof. I'm going to add this motion to your to this motion, your inappropriate statements, which again you made yesterday or implied yesterday that I'm making a false statement. If you're trying to limit Fowtech and if you're trying to limit Fowtech to just one issue is frankly silly. It's not Floortech, it's Fowtech, and it says you can make offers of proof. And the interrupting here, so please make an offer of proof. As you understand, I'm sure this court reporter can only take down one person's testimony at a time. So if not as a courtesy to me, then at this point, then to nobody else, if you could kindly stop interrupting me while I'm making my oral motion and protecting my client's record here. ALJ defort. The only issue here, for these reasons, ALJ defort. The only issue is all the reasons I said it above. The only issue here that we're here to discuss, I need to request your recusal. The only issue that we're here to discuss at this moment that you've asked the witness to leave the room for was your offer of proof. So you need to make an offer of proof as to why your viewing of deliberate indifference, which is the YouTube channel, why is that relevant? Okay, that is an offer of proof consistent. I just made a motion here. Just stop. Stop it. I need a ruling on my motion. ALJ defort, I'm asking you to make an offer of proof. Mr. Hitchcock Cross, right. Consistent with foul text. So please make an offer of proof as to why this witness's viewing of the YouTube program is relevant to your client's case. Mr. Hitchcock Cross, I'm happy to do that. The issue is that I've made a motion that I need a response from my colleague here. Then I need a ruling on my motion because again, your decisions here and your display of bias necessitates your recusal, and that's what we're moving for. ALJ defort. Any response? Ms. Kohlberg, we've made our objections related to the relevance of this. There's been no offer of proof made, so we're maintaining our objection that anything pertaining to deliberate indifference Wisconsin is irrelevant to the complainant certified issue. I agree. At this point, there's been no showing of relevance as to what this witness, what her viewing of this YouTube program has anything to do with Ms. Falleron's case. I'll give the complainant an opportunity to make an offer of proof. None has been made. Instead, there's a motion to recuse because I'm asking for an offer of proof. Huh. So at this point, it sounds like the complainant, as I've told him before, complainant's counsel, if he refuses to make an offer of proof, he's agreeing with the respondent that there's no relevance to the offered evidence. This is your opportunity. I don't want to exclude evidence that is relevant, but you have made no offer of proof. Still nothing? Mr. Hitchcock Cross. So again, this is part of the problem here with your demeanor towards these proceedings is comments like still nothing, or he only made a motion. And this is by you as a misstatement that my motion was limited to one issue. I went over just seconds ago your conduct which necessitated the motion. The refusal to allow her to answer simple questions, the tone and tenor of your comments, and you're interrupting me while I was making a motion. Those were all of the grounds that I did it. So your statement there was incorrect. Now, as to deliberate indifference, Wisconsin, there are many issues touching the complainant's channel that are exhibited, complaints that are exhibited on this channel. So much of my question to her is going to be, has she viewed these videos and other evidence on that channel already? And has that formed a part of the basis of her knowledge about these complaints? And I'm still waiting, though, for a decision on my motion, on your motion for recusal. Mr. Hitchcock Cross. That's right, sir. Okay. Is there any response from the respondent on that motion? Ruling on an evidentiary issue is not basis for the ALJ to recuse himself in this matter. I'll leave it to the ALJ's discretion, but I don't see a basis for it here in the record. Anything else? No, thank you. Mr. Hitchcock Cross, if I just might reply. So one thing that I might read from Fowtech is the quote there that heavy-handed restrictions on evidence are disfavored. So I don't know what that has to do with offers of proof. Maybe something else. Maybe you can tell me I don't know. Maybe it's the case that Fowtech speaks to more than one issue. Maybe you can let me know. Okay. Maybe you can let me know. Okay. The motion to recuse is denied. I'm trying to rule consistent with 227451. Notice he dropped Fowtech on what is cumulative and what is immaterial. What is irrelevant evidence versus evidence that is relevant. So at this point, the motion is denied. I know that that was a lot. So let me just pull this apart here. There is a case at Lurk in which I'll read out on the record, I think on like day 7, which basically says that the judge is to let all the evidence in. He knows that because he says he's read this decision, and he says it's about making offers of proof, not heavy-handed evidentiary restrictions, and says that I made a false statement when I said what Fowtech was about. He says it's only about um, offers of proof. So we'll see if that's true or if his accusing me of making a false statement is actually, what reasons could this judge have to misquote the statement of law that says that he has to allow in all the evidence? I mean, maybe we just spent 45 minutes talking about the just getting a simple answer to a simple question, one simple question, which was, ma'am, did you receive this cover letter? This cover letter here that we're talking about. I know you said last night you received a cover letter, but this one here, that's the one we're talking about. Did you receive that one? Can't ask that question. Okay. And he's not only is he's saying that the law, the decision on which the Fowtech is not going to say that, and we're going to quote that in the next video. So we'll see how that goes. Okay. So thanks for sticking with us. We'll keep you informed.